Hello everyone, this is Anukriti Jain, a second year law student pursuing BA Honours from Institute of Law near my university. Also, I am currently interning at a law firm, Sejpal Associates, Ahmedabad. In this video, I will be discussing the tribunal system in India. So let's begin. Now the very first question arises before us is what are tribunals? So tribunals are basically institutions established by law. They are established for discharging judicial or quasi-judicial duties. The main purpose, the main objective behind establishing tribunals were to reduce caseload of the judiciary and also to bring in subject expertise for technical matters. The Supreme Court has also ruled that tribunals, being quasi-judicial bodies, should also enjoy the same level of independence from executive as the judiciary enjoys. The key factors include here are the mode of selection of members, the composition of tribunal, and the terms and tenure of service. In order to ensure that tribunals are independent from executive, the Supreme Court has recommended that all administrative matters should be managed by a single ministry, that is, the Law Ministry. Later, the court also recommended that creation of an independent National Tribunal Commission for administration of tribunals. Whereas the reasoning of setting up some tribunals was to reduce the pendency of cases in the court. But now several tribunals are facing the same issue, that is the large caseload and pendency of cases. Now we'll discuss the evolution of tribunals. Since we have already discussed that why these tribunals were established in the first place. The same was also noted by the Law Commission of India in the year 2017. It said that pendency in court leads to delay in the administration of justice, thereby impacting the efficiency of the judicial system. Now we'll discuss how the tribunals came into existence. So in the year 1976, two articles, that is 323A and 323B, were inserted in the Constitution of India. It was inserted through 42nd Amendment. Article 323A empowered the Parliament to constitute administrative tribunals, that is, on both the level, central and state. These were established for adjudication of matters related to recruitment and condition of service of public servants. Article 323B specified certain subjects such as taxation and land reforms for which Parliament or state legislature may constitute tribunals by enacting a law. But in the year 2010, Supreme Court clarified that subject matters under Article 323B are not exclusive. So the legislatures are empowered to create tribunals on any subject matters under their purview as specified in the 7th schedule of the Constitution. Now we'll discuss the key Supreme Court judgments related to tribunals. So the very first case before us is SP Sampath Kumar versus Union of India and others 1986. In this case, the Supreme Court said that it is constitutionally valid for Parliament to create an alternate institution to High Courts with jurisdiction over certain matters, provided that the alternate body has same efficacy, that is the same efficiency as that of the High Court. Such tribunals will be considered substitute of the High Courts. The Supreme Court also emphasized on the point that how appointments should be made. The Supreme Court said that it should be made either by the central government after consultation with the Chief Justice of India or by a high-powered selection committee headed by Chief Justice of India or a current Supreme Court judge or current judge from the concerned High Court. The second case before us is L. Chandrakumar versus Union of India and others 1997. In this case, the Supreme Court said that a tribunal which substitutes High Court as an alternative institutional mechanism for judicial review must have the status of High Court. Such tribunals will act as courts for first instance in respect of areas of laws for which they have been constituted in the first place. But the decisions of these tribunals will be subject to scrutiny by a division bench of the High Court within whose jurisdiction that certain tribunal falls. Next, the court said that any weightage in favor of non-judicial member would render the tribunal less effective and potent than the High Court. Therefore, only person with judicial experience should be appointed to the tribunals. To ensure uniformity in administration, a separate independent mechanism should be set up that we have discussed in the second slide, where a National Tribunal Commission was recommended by a Supreme Court to be set up. But until then, the tribunals should be under the administration of a single ministry, that is the Ministry of Law. Now we'll discuss the third case, that is R. Gandhi versus Union of India in another 2010. In this case, the Supreme Court said that Parliament may create alternate mechanism to High Court on subject matters that is mentioned in Union list. The Supreme Court also said that there is no need of a technical member if the jurisdiction of the court is transferred to the tribunal solely to achieve the expeditious disposal of matters. The court also said that in any bench, technical members must not outnumber judicial members. Here the term technical members are for those secretary level officers with specialized knowledge and skills on that particular subject matters, and they should be called technical members. So the Supreme Court said that in any bench, technical members should not exceed the judicial members. Now we'll discuss the fourth case, that is Madras Bar Association versus Union of India in another 2014. In this case, the Supreme Court clarified on the eligibility of the technical members. Here, the court said that Group A or equivalent rank officers with experience in the Indian Company Law Service and Indian Legal Service cannot be considered for appointment as judicial members. Such officers may be considered for the appointment of technical members. The court also said that all the administrative support to the tribunals should come from a single ministry, that is the Ministry of Law and Justice. Neither the tribunal nor their members should seek or be provided with the facilities from the respective parent ministry or the concerned department. They should all seek help and facilities from Ministry of Law and Justice only. Now the fifth case, that is Roger Matthew versus South Indian Bank Limited and others 2019. Here again the Supreme Court emphasized on the status of technical members, that judicial functions cannot be performed by technical members. They are only there to assist the judicial members on that particular subject matters. Provisions to allow removal of judges by the executive is unconstitutional. Also, the court said that there should be a uniform age of retirement of all the members of the tribunals. The court also touched upon the topic that short tenures lead to control of executive over tribunals, causing adverse effect on the independence of the judiciary. Therefore, there should be a uniform tenures which are not short in nature. Now the next case, that is Madras Bar Association versus Union of India 2020. It's a very recent case. In this, the Supreme Court said that members will have a term of 5 years instead of 4, and the members will also be allowed to hold office till they reach 67 years of age instead of 65. The court again emphasized on the establishment of the National Tribunal Commission for supervising appointments as well as functioning and administration of the tribunals. Last but not the least, the Supreme Court in the case Madras Bar Association versus Union of India 2021, the court struck down provisions related to the 4-year tenure and a minimum age requirement of 50 years for members. Now we'll discuss about the independence of tribunals. I cannot emphasize more that the tribunals must be free from executive interference. Any involvement of the central government in the administrative activities of the tribunals would affect their independence. The Supreme Court, while reviewing the National Tax Tribunal Act 2005, stated that when a tribunal is vested with the jurisdiction of the High Court, the tribunal must be free from executive interference. The components which determine the independence of the tribunals include the selection process of the members, the composition of the tribunals, the terms of the office, and the service condition of the members. All these components we will discuss in detail in the next upcoming slides. Now we'll discuss about the selection process of the members. In 2019, the Supreme Court reiterated that the lack of judicial dominance in the selection committees of the tribunals violates the doctrine of the separation of power. Further, the court clarified that the executive is often a party in litigations and hence they should not be allowed to be a dominant party in the judicial appointment. The mechanism for appointment and removal of members in tribunals and the tenure of their employment should have adequate protection from legislative as well as executive interference. Therefore, finally in November 2020, the court specified that the selection committees of the tribunal should consist of the Chief Justice of India or his nominee with a casting vote. Second, the presiding officer of a tribunal or a retired Supreme Court judge or Chief Justice of High Court in the case the presiding officer is not a judicial member or if he is seeking reappointment. Third, Secretary to the Ministry of Law and Justice. Fourth, Secretary to the central government from a non-parent ministry. Fifth, Secretary from the parent ministry. Now we'll discuss about the composition of the tribunal. The tribunal consists of two types of members, that is the judicial members and the technical members. The Supreme Court has noted that members of tribunal may be selected from the departments of the central government as well as from various other fields of expertise. The primary difference between court and the tribunal is the presence of the technical member, that is specified or expertise in a particular subject matter. Only a person with a judicial background such as judges of High Court or lawyers with prescribed experience who are eligible for appointment as High Court judges may be considered for the appointment of judicial members. Now we'll discuss the terms of office and service conditions of the members. Remember, previously we have discussed in the Supreme Court judgment Roger Matthew versus South Indian Bank Limited 2019, where the Supreme Court said that short tenures lead to control of executive over the tribunal, causing adverse effect of the independence of judiciary. The main reason behind Supreme Court saying this was that in such a short term of office, by the time the members achieve the required knowledge, the required expertise and efficiency, the one term gets over. This basically prevents the enhancement of the adjudicatory experience, thereby impacting the efficacy of the tribunals. Therefore, to prevent this, in 2020, the Supreme Court stated that the term of office for the chairperson and other members must be 5 years, subject to maximum age limit of 70 years for the chairperson and 67 years for other members. Now we'll discuss the administration of tribunal. In the year 1997, the Supreme Court recommended setting up of an independent mechanism for uniform management of appointment and administration of tribunals. Subsequently, in 2014, the court also specified that the administrative support for all tribunals should be from the Ministry of Law and Justice. Further, the Standing Committee on Personal Public Grievance Law and Justice 2015 recommended that creation of an independent body, that is the National Tribunal Commission for the administration of the tribunals in India, should be formed. Again, by the Supreme Court in the year 2020, it was emphasized that creating NTC to supervise appointment as well as functioning of the administration of the tribunals is very necessary. However, till now the National Tribunal Commission have not been created. Now we understand the difference between courts and tribunals. It is very basic in nature and yet often confused with one another. Courts. Courts are part of traditional judicial system wherein the powers are derived from the state, whereas the tribunals is an agency created by a statute that is invested with judicial powers. The courts give judgments, decree, conviction or acquittal, whereas the tribunal give awards that can be monetary or non-monetary in nature. The judges of the court are independent of the executive, whereas in tribunal, the members of the tribunals are entirely in the hands of the executive. The court of law are bound by all the rules of procedure and evidence, whereas in tribunal are bound by the principle of only natural justice and not the civil procedure courts. The court deals with a variety of cases such as criminal, constitution, etc. The tribunal deals with a specific case. For example, the National Company Law Appellate Tribunal is formed within a statute, the Companies Act 2013, and deals with the specific company matters. Now we'll discuss the appellate courts for some tribunals in India. For example, the Industrial Tribunal that is formed by the statute, the Industrial Disputes Act 1947, and the appellate court for the same is the High Court. The appellate court here means a court consisting of several judges instead of a single judge bench, who typically analyzes and review the decisions delivered by the tribunal. Now we'll discuss the Tribunal Reforms, Rationalization and Condition of Service Bill 2021. This bill was introduced in Lok Sabha on February 13, 2021. It was withdrawn from the Lok Sabha on August 2, 2021. It proposes to dissolve certain existing appellate bodies and transfer their function to other existing judicial bodies. Further, it also proposes to include provisions related to the composition of selection committee and the term of office in the Act itself, to which the answer is the term of office for the chairperson and member of tribunals will be 4 years, subject to an upper age limit of 70 years for the chairperson and 67 years for the other members. The bill also specifies that a person should be at least 50 years of age to be eligible for appointment as chairperson or members. An ordinance with similar provisions was also promulgated in April 2021. The same was challenged in the Supreme Court over its lack of compliance with the past Supreme Court judgments on tribunals, which we have discussed earlier in this video. Further, in July 2021, the court struck down certain provisions of the ordinance. The bill proposes that certain existing appellate bodies herein mentioned should transfer their functions to other existing judicial bodies. For example, Appellate Tribunal under Cinematography Act 1952, whose role is to adjudicate of appeals against the Board of Film Certification, should transfer its function to the proposed entity, herein the mention, that is High Court. Now the main key issue is the High Courts are already burdened with large number of cases that are awaiting judgments, and putting burden on them is not a solution. It basically defeats the whole purpose with which these tribunals were set up in the first place, which was to help reduce the burden of the High Courts. Here are some more appellate body which needs to be abolished as proposed in the bill. I hope you found this video useful and informative. Thank you for watching.